Hello friends, Mandar here. I'm back with another video. Today we'll take a look at some news that is coming in immigration space that has to do with administration giving legal status to undocumented immigrants, some news regarding speed up of the non-immigrant visas to be given to the students who have graduated from US universities, some policy guidelines regarding children receiving citizenship, another guideline that provides more and more occupations that are eligible to skip the PERM process, which will highly speed up the green card process. Processing time for PWA and DOL. An interesting topic, what may happen to the EB category in visa bulletin towards the end of the year and also in the October visa bulletin. Lot of packed content guys, you might find something interesting. Watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration and lifestyle related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Check out the links in the description because those are affiliate links and you might find something interesting. And while you are down there, do hit the like button. This video is sponsored by Exter and I'll come to that in a moment. Now let's look at the first topic of today. Now I came across this news that Biden preparing to offer legal status to undocumented immigrants who have lived in the US for more than 10 years. Now this is no news that the Democrats or the Biden administration is pro undocumented immigrants, but let's see what's being done for this particular topic. So what it says is the Biden administration is making plans to announce one of the largest immigration reform relief program in the recent history by offering legal status to hundreds of thousands of immigrants living in the country without proper documentation and without proper authorization. So isn't it interesting? Anyways, the program being developed by the White House would offer work permit and deportation protection to unauthorized immigrants married to US citizens as long as they have lived in the US for at least 10 years. The proposal, also known as parole in place, would open a pathway to permanent legal residence and also US citizenship. So I have been getting some calls lately regarding what are the pathways to US citizenship and US immigration. And one of the pathways that I have been talking about to people recently is marriage based pathway. It seems like if you run out of options on all other legal processes, try to find a spouse who is a US citizen, and that will lead you to the pathway of green card and US citizenship. And so that's the reality. That would be the fastest way you could become a permanent resident or a US citizen. That's the legal route. If somebody asks me what is the fastest route, this is it. Now whether you should do it, whether it's ethical, that's totally up to you. My job here is to tell you what is that pathway. Another plan being prepared by the Biden administration would streamline the process of so-called dreamers and other undocumented immigrants to request waiver that would make it easier for them to obtain the visas such as H-1B and high-skilled immigrant visa. So how many people we are talking about? It's about 530,000 undocumented immigrants brought to the US as a children, and they will be protected from deportation. So if you have been married to a US citizen for more than 10 years, regardless of how you came into the country, you will be protected from deportation and you will be given EADs and pathway to US green card and US citizenship. So that's what it says. I haven't got a confirmation whether this has turned into a law, but if I find that, I'll let you know. Now here are the sponsors of today's video, Esker. So do check out this oil slick card holder and a finder card compatible with Apple Find My. This tracker will make sure that you never lose your wallet. It even has a charging cable, so this tracker never runs out of battery. Now the most interesting thing about this wallet is that it has a button at the bottom, which when you press, it pulls out all these cards nicely. There is a summer sales campaign going right now from July 7th to August 21st, and with the promo code WISDOM, you will get 25% off. So enjoy your Esker's summer sale offering 25% off using my code WISDOM at the checkout to unlock further savings. Use the link on the screen and in the description. Thank you for your support and thank you Esker for sending me these products. Now second topic of today is USCIS will speed up the non-immigrant visa issuance to people who study or graduate from the United States. So let's look at what it says. Now it specifically says that US to speed up employment based non-immigrant visas for graduates with job offers. That is something like you graduate from the university, you have the 3 years OPT, you have a job offer. If you do, then they will prioritize the issuance of non-immigrant visa to you, which is H1 or O1 or something like that. So the Biden administration has announced new steps to speed up employment based non-immigrant visa for college graduates with job offer. This move aims to help the US economy and keep skilled workers, which is part of the effort to make immigration process easier and to attract top talent to the United States. The administration intends to simplify current procedures to expedite the issuance of these visas. Now let's look at which particular visa it talks about. The employment-based non-immigrant visa lets foreign workers to come to the US and temporarily. Usually that visa is through filing the petition at a particular time and going through the cap subject through H1B visa, among other temporary work. Now it is well known that if you have a job offer and if your employer is willing to sponsor you for an H1B visa, they can easily file an H1B visa through the lottery program for you. Now if your company is cap exempt or non-profit, they can even apply an H1B for you any time of the year. But if it's cap subject, it's only one time of the year, which is end of March when it will apply. So I'm not very sure what it means by expediting the applications or expediting the non-immigrant visas issuance, those who study in the US and have a job. It would basically mean that if you apply for H1B, your application, and if your application is picked up through the lottery, you will get the confirmation of your approval sooner than sitting on it until October. You can plan for your job to start in October because you will get earlier indication that your visa has been approved. So that's what I understand from this news. I'll expect that more details will be issued soon, but let's see what happens. Now the third topic is USCIS issues policy guidance on children's acquisition of citizenship. Now this came in on 18th of July. USCIS is updating guidance or USCIS policy manuals regarding provision for children's acquisition of citizenship, because there are exhaustive categories of where children become eligible to apply for US citizenship. So let's see. Now this guidance affirms that the applicant who has already filed application for certificate of citizenship and were denied but become eligible following a change in the US policy may file a motion to reopen prior to USCIS denial of their application. So typically the process USCIS follows is, if they want to deny an application, they will send you a notice of intent to deny. Now there is a period between the notice of intent to deny to actual denial of your application, and between this period you can apply for motion to reconsider or motion to reopen if you have a strong evidence that your case is still fightable in the immigration court. So that's what it is. If the USCIS parent was in the US illegally prior to obtaining their citizenship, as long as they can establish the residency before the birth of the child, they will still be eligible to file for US citizenship for their children. So basically what these things mean in a nutshell is they are relaxing many rules or interpreting them in such a way that it's beneficial to the beneficiary of applicant for US citizenship. Don't you wish that they would do the same for employment based immigration? Now let's keep going. Now there is also another news that H1B visa reforms for students to stay in the US after studies proposed by the congressman. So it's just another version of what I just covered, that they will make it easier for people to stay back in the US after they have completed their studies by offering their visa such as H1B or making it available faster than normal. Now the Congressman Shri Thanedar proposes to keep the STEM Graduates in America Act, aiming to streamline the visa process for STEM graduate in the US. To keep STEM Graduate in America Act aims to boost H1B issuance and simplify the application process for international STEM graduates in the US. Now I just wanted to kind of highlight this information to you. If you find more information about how they are going to actually execute this rule, please let me know, because I couldn't find any more details other than these news flashes. So let me know in the comment section below what you think about these news, whether they have any truth to it or is it just a news flash in the election. Now the next one is important because this one has to do with which are the job classifications that USCIS will use to determine if the individual needs a PERM process for their green card application or not. Remember, the PERM application takes very long. It takes about a year or a year and a half to process before you can go to I-140 application. So if there are more categories that will allow individuals to skip the PERM like they do in EB1 cases, then it's even better or faster for an individual to get their green card. So let's look at what it says. Now Schedule A Group 2 allows the individual to match their criteria just like in EB1A or EB2 NIW and qualify them to skip the PERM entirely. Now this is the Schedule A designation petitions. Basically, eligibility for Schedule A designation is the requirements are the employer must offer full-time permanent employment to the beneficiary. The employment must be in one of the occupations categorized in Schedule A occupation. The employer must offer beneficiary at least the prevailing wage. The employer must provide the notice of the position it seeks to fill to the employer's bargaining representative if applicable, and then the beneficiary must meet USCIS eligibility requirement. Now let's look at the job classification in this Schedule A. Now if you look at the job classifications mentioned here, Group 1 physical therapist and professional nurses, and Group 2 immigrants of exceptional ability in the areas of science or arts, including college and university teachers and immigrants of exceptional ability in performing arts. So now it is a broad category of science and art. If you are teaching, if you are performing, if you are in the college or university as a professor or a teacher, you may be eligible for this Schedule A classification, which will allow you to skip PERM process entirely. I would always suggest that you meet an immigration lawyer and discuss your scenario with them and whether you qualify for your PERM exception. Now I'm not going to go into each and every particular category, but if you think that you qualify, do reach out to me or do reach out to a lawyer that is knowledgeable enough, because they don't want to do that research. So make sure that you talk to a good immigration lawyer if you think that you will be able to skip the PERM process based on your occupation. Now another popular topic I get is, because there is a lot of layoffs happening in the market, some people have asked me that when can you start your new job? So remember, there is a 60 days grace period for your H1B. Once you lose your job, start counting from the last day of the payroll. So if the last day of the payroll is such and such date, even if you get severance or even if you get a continuation of the pay, that counts towards the 60 days. So it's the last payroll date, the last day you were in the office and got paid. That's where you start counting your 60 days. As long as you have found the next job and the employer who is willing to sponsor or transfer your H1B, and as long as they have filed the petition for the transfer, you are eligible to start the new job. You don't have to get the approval before the 60 days. So hope that clarifies. And then I wanted to talk about the Department of Labor processing times that they have displayed. It's ridiculous what they have seen. I'll put the link in the description for you to go and look at your service center. Be sure to check out those links. In a nutshell, there are 3 steps in the PERM processing. The first is prevailing wage determination, PWD, which can take anywhere from 3 weeks to up to 3 months. The second thing is posting the job, because job has to be posted for 30 days. Then there is a 30 days cool off period. This allows the company to search for an alternate candidate who is already in the United States and rule out any non-eligible candidates. This will allow them to establish that they couldn't find any eligible candidate within the US, and thus they want to file the green card petition for you. That is the second stage. And then the third stage is actually filing PERM application with the Department of Labor. Now this PERM processing can take up to a year, given that you do not get any audit. If you get any audit, that could take another 4 to 6 months on top of the normal processing time. So then on an average, I would say the PERM processing can take anywhere between 12 to 18 months. Now I also want to remind you that I am doing a masterclass on EB1A this Sunday, which is 28th at 11 AM Eastern Standard Time. So if you are interested in upgrading your case to EB1A, which is coming close to current, you can attend my masterclass, because I go into the intricate details of each eligibility criteria and then the real world evidences that you can gather to be eligible for this EB1A. Many people have attended my masterclass and they have benefited from it. This will allow you to prepare for the EB1A, because EB1A is self-petitioning. It is your preparation. Don't go blindly without any preparation into this process, because that will set you up for failure. So prepare yourself, know the criteria, know what are the documentations that are needed, and you will be successful in that. There are a lot of questions regarding whether EB1 will become current in the October visa bulletin, and my speculation is If not current, it will be very close to current. We have seen the numbers. There are almost 10 to 12,000 pending visa applications as of March. Many of those would have been processed, but then again many people are also upgrading their petitions, and that is an unknown number to the USCIS, because USCIS doesn't know how many people will apply for EB1A that are already waiting in EB2 or EB3. And when they do, they bring their older priority date, which puts them right in the front of the line ahead of you. So that is the trick for EB1A. So nobody can speculate whether it will become current, but my best judgment is it will be close to becoming current in October visa bulletin. EB2 and EB3 have no chance to go anywhere beyond 4 to 6 months in October visa bulletin. Let's see, because spillover numbers from FB category are still unknown. If we get a clue of those, we'll find out what happens. And in the August visa bulletin, we were told that EB3 category in the rest of the world will retrogress even further and even become unavailable, which concerns me, because the visa numbers will run out any time from now on, which means there will be no spillovers into the backlog countries like India. So not so much of a good news for EB3 category. This time I did not make a video on visa bulletin because I'm extremely busy with my work, but I'll be sure to make the video on the September visa bulletin as soon as it comes within a week or two. If you want to reach out to me and talk to me, please reach out to me on Calendly, where you can book 30 minutes call with me, and that will be the best way to get your questions answered. That's all I wanted to talk in this video. If you like the content of this video, do hit the like button and consider subscribing to my channel, and I'll see you in the next one.